Hello aspirants, welcome to Excellence IAS Academy. Today we will discuss about Unlawful Activities Prevention Act. In earlier video, we have discussed about the features of Unlawful Activities Prevention Act and its amendments. In this video, we will discuss some of the arguments with respect to Unlawful Activities Prevention Act of 1967. Let us begin. We will first see what are the arguments in favor of this particular law, and we will jump into arguments against this particular law. Firstly, national security. Government often claim that if we have to protect national security from any external threats or internal threats, we need to have any such kind of law where it can punish both individual and organizations. Such opportunity has given by Unlawful Activities Prevention Act of 1967, and also to curtail terrorist, also counter-terrorism activities should be taken in the country. So if we have to take such activities or counter-terrorism measures, Unlawful Activities Prevention Act is also one of kind. So this gives us to punish terrorists, not only Indian terrorists, also international terrorists, because India is the 14th largest terrorist victim in the world. Means India ranked 14th in the Global Terrorism Index of 2024. Thirdly, we need to curtail secessionist activities in the country. Subnationalistic tendencies are in the rise. For example, Khalistan issue and Jammu and Kashmir issue. And also secessionistic tendencies are happening in Northeast, for example, Greater Nagaland. So such issues are should be curtailed and tackled. Such should be done under the Unlawful Activities Prevention Act. And also, India need to have global commitment. India always put forth the idea of anti-terroristic measures in international level. If you don't have a law nationally, so it will be a very much setback for India in international level. So that is one of the major arguments in favor of the particular law. And also, what against? What are the arguments against a particular law? Says that definitions are very vague. Such vague definitions may lead to subjective interpretation. Subjective interpretation may lead to detention of a wrong person or innocent person, which may lead to violation of the fundamental rights. And also, second such argument is that this may lead to political vendetta, where political parties or a present government can use this law to detain or suppress political dissents who are human rights activists, tribal right activists. Such tendencies may lead to hatred politics in the country. And also says that there is no safeguards for the individuals who are detained under this particular law, because the proof of burden falls under the accused, who should be proved to the authorities that he is an innocent person. That is very difficult task to do. And also says that political thinkers have also raised that conviction rate is very low in this particular law, because only 18% of the cases registered under this particular law are resulted in conviction. So this shows that how law is misused in the country. This is overall arguments in favor and against about this particular law. We will come up, but in recent days, in various cases, Supreme Court have highlighted there are concerns with respect to this particular law. We will come up with those particular judgments and the verdicts about this particular law in coming days. Thank you.